Okay. Thank you to everyone who's joined already. I'm sure it looks like we still have some people signing in, but we will get started with some housekeeping items first. Thank you so much for joining us for another installment of our Government Contracts Academy, CLE. And today we're going to be covering intellectual property rights and government contracts. We are excited and happy to be here with you all to present and talk about this program and this updates happening in intellectual property rights and changes that have been happening in the rules, and some case updates as well related to some disputes. But before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the Q&A box at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program, but we will make sure to be checking the Q&A box throughout the presentation this morning and try to answer them in real time as much as possible, as much as we are able to. Please note that today's webinar will be recorded and it will be circulated to all registrants via email after the event. Should you have any follow-up questions at that time, please reach out to Steve, Rachel, or myself, and we will be happy to get back to you with responses as quick as possible. In our email community, there should be our email information in the email communication that you received related to this program. Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. One other important note is that if you have a New York, New Jersey, or Pennsylvania license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you do not have a New York, New Jersey, or Pennsylvania license, you can disregard this. This program has been approved for 1 general hour of CLE in Arizona, California, Georgia, Illinois, Iowa, Missouri, New Jersey, New York, Pennsylvania, and Texas. It is pending approval in Colorado, Indiana, and Virginia. Now, on to today's session for intellectual property rights and government contracts, and I'll kick it off to Rachel.
Thanks, Megan. So this is your standard agenda slide and is going over what we're going to cover today. Starting by way of introduction, we have the benefit of our practice group leader and our fearless leader, Steve Masiello, talking with us today. Myself, Rachel Van Maasdam, I'm a managing associate here in the Government Contracts Practice Group in Denver, and Megan Fackler is an associate here in Denver as well. So today we're just going to be going over a quick overview of IP topics and government contracts, just to orient the audience to the meat of the presentation, which is really rule changes and case updates as it relates to some specific IP topics in the context of pre-award considerations, performance considerations, and disputes. And hopefully we will not talk too much, and there will be some time for some question and answer. Please feel free to drop those into the box as we go. And if there's a good breaking point, we'll try and answer as we go along, but certainly we will cover them at the end to the extent we can. Next slide, please. So this is just kind of a general overview of what we mean when we say IP in the government contract space. It does include what people traditionally think of when you think of IP, which is patents and inventions and things of that nature. But a lot of what causes a kerfluffle in government contracts is that second category of technical data and computer software, because it involves sort of specialized topics like technical data. What is that? What rights the government has in a contractor's IP, having to mark those things, and then make certain disclosures. So that's really a specialized area of IP for government contracts. Next slide, please. And so really the majority or the major source of conflict in government IP comes with the competing interests of the government and with a contractor. The government is essentially always seeking more ownership in contractor IP and data, and the contractor is always interested in resisting that to try and protect its proprietary information, its talent, its procedures, protecting it against use by competitors. So what governs what the rights the government has are these three things right here, which is the type of IP at issue, the type of agreement you have with the government, and potentially the agency at issue. So whether you're dealing with the Department of Energy versus the Department of Defense, there may be different rules for rights in IP. Next slide, please. And this is just a very broad overview of the statutory and regulatory construct in which you operate in the IP government contract space. Generally, the act that allowed contractors to keep their own data to begin with is the Baugh-Doyle Act, if I'm saying that right, implemented through the executive order noted on the screen, 12-591. Back in 1980. And then obviously we have multiple FAR clauses that govern this, and their presence in your contracts are going to be what dictate how you have to deal with your IP and the government. And then for anybody in the audience who does significant business or is part of the DoD, the DFARs also have an extensive amount of clauses. So if these are also present in your contract, these are going to add an extra layer potentially of IP issues that you might have to deal with. So each one of those clauses could probably be its own Denton's Academy. Some of them could be their own semester in law school, and we obviously do not have time for that. So this is just kind of narrowing in on what the rules and cases are going to cover that we're going to talk about today. It's typically your traditional battleground, which is which rights does the government have in your IP? Unlimited rights, limited rights, restricted rights, and the government contract specific government purpose rights. There's a lot of fighting over what the government has, despite the fact that the clauses should lay out what it is they have. This tends to be where there is a lot of conflict. Increasingly, data marking and software licensing are what we're seeing in the court space, in sort of what we're seeing litigated. These are becoming increasingly combative between the government and contractors, and we're going to go over some of those cases, but data marking is what the contractor is required to mark under the terms of the contract as essentially it's data or it's IP, and then that dictates what the government's rights will be. And so there's a lot of argument sometimes about whether or not it should be marked, whether it's marked appropriately, and conflicts like that. And then software licensing, you'll see a good chunk of cases that we're going to talk about today with regards to that. There has been an increase in litigation with regards to the government appropriately using the software licenses that it agrees to, whether it agreed to the terms to begin with, and a lot of issues with popping up with regards to software licensing, both in the commercial area and in what is developed under a government contract. And with that, I will turn it over to Megan to get us started on the rule and case updates with pre-award considerations.
Thank you, Rachel. All right, we are going to move right into some of the rules that are changing in just in the past couple of years. To kind of start off this discussion, we're going to go to a case that has kind of sparked new rules that that are pending that we'll talk about in a few slides. But this case is Boeing versus the Secretary of Air Force in the Federal Circuit. For background, this was related to the regulations that allocate technical data rights between the contractors and the government. And specifically in here, they were talking about addressing the clause, which is DFARS 252, 227, 7013. This, I'll refer to it as clause 7013, so it's not as much of a too many numbers, but this clause 7013 addresses the contractors and the government's respective rights and non-commercial technical data, as well as the contractual obligations for protecting those rights. So usually this clause states that contractor grants the government one of 4 licenses, and that's the 4 that Rachel just mentioned. But anything that the contractor does not grant to the government, the contractor retains those rights. So 7013 in that issue in this case specifically talks about markings, legends, and technical data markings that you put on your data related to how it restricts the government's rights in that technical data. So the clause specifically provides that the contractor should place restrictive markings on data when it desires to restrict the government's rights in the technical data. And any rights that are not in line with this clause, or any markings that are not in line with this clause, the government may reject as non-conforming markings. So what happened in this case is that Boeing was delivering technical data to the Air Force with unlimited rights, which means the government has the right to use, modify, reproduce, perform, display, release, and disclose the technical data for any purpose whatsoever, and to authorize others to do so as well. So these were unlimited rights that the government had. Boeing marked each technical data deliverable that is submitted to the Air Force with a legend that purports to describe Boeing's rights in the data as it pertained to third parties. So Clause 7013 provides for different types of restrictive markings that can be placed on the data when it relates to restricting the government's rights. And in this case, Boeing was putting legends on the data as it related to third parties' rights. The government did not agree with the Boeing's placement of that legend and rejected the technical data deliverables because it is not in the format authorized by the contracts pursuant to Clause 7013, subsection F. The ASPCA originally agreed with the Air Force and said that the Boeing's legend was not one of the 4 allowed under the 7013 clause and therefore was non-conforming. However, the Federal Circuit disagreed and found that 7013, based on its language, only applied when a contractor elects to assert restrictions on the government's rights. 7013 is silent on any legends that a contractor may mark on its data when it seeks to restrict only the rights of non-government third parties. So that was the key distinction here, is that the legends were not purporting to restrict the government's rights in the data, but third parties. And therefore, the Federal Circuit found that it was permitted it was not prohibited by the Clause 7013. And this is key because we will talk about this in the next coming slides. There has been a rule recently coming out that is trying to clarify that and make it so that legends purporting to restrict third parties' use of data may also be governed by the DFARS. So we'll have to look forward to that, and we'll talk more about that in a minute. In contrast to this Boeing case, we also have the Flight Safety Board case, which took issue with the contractor's more generic commercial markings. So the Boeing case was about non-commercial technical data. In the flight safety case, Flight Safety was a subcontractor to a prime contractor that flowed down the commercial technical data and validation clauses. And in this case, the government was claiming that the Flight Safety's drawings, technical data that it was submitting, though it was commercial, was OMIT data, which OMIT stands for operation, maintenance, installation, or training data, and that the government had an unrestricted license in that data. Flight Safety eventually agreed that the government had an unrestricted license in the data through a settlement process. But what was at issue in the ASPCA case was that the plain language of the commercial technical data clause permitted the Air Force to manufacture additional items using technical data subject to the unrestricted rights license, because the manufacturing restrictions in the DFAR 7015 clause do not apply to the unrestricted rights license provided. So here we're talking more about how the board decided that there, and the most relevant to what the Boeing case talked about, is that the board found that any commercial restrictive legend that was inconsistent with the license rights the Air Force obtains under the contract was not substantially justified. And because flight safety had proprietary commercial markings on the data that they delivered. And the key difference between the Boeing and flight safety case is that Boeing's legends did not apply to the government's rights, while flight safety's legends did purport to restrict the government's rights in contradiction of the license rights the government had under the contract. And so that was the main difference between these. Also related, which I kind of alluded to as well, is this new DFARS case, which proposes a new unlimited rights legend be applied to non-commercial and commercial technical data. And this is, we'll talk a little bit more about that in the next slide. So this is going into what the rules are changing. So we're going to have some DFAR cases and FAR cases that are changing, that have already recently been made into final rules or on the horizon and still being considered, and that we should look out for, that might be affecting government contractors' technical data rights. So this first one with 2019 D043, this is a proposed rule that we that deals with deals with the open-ended marking requirement for commercial technical data in DFARS Clause 7015. So this rule would preserve the contractor's discretion in choosing and using its favored restrictive markings consistent with commercial practices or other contractor preferences, while clarifying only that the restrictive marking used must accurately reflect the government's license rights. Sorry, I'm just reviewing my notes just to make sure that we're discussing the key issues there. Okay, and then with this first one, I do want to mention that as it's kind of in response to the Boeing case, this proposed rule includes revisions to the requirements governing restrictive markings to clarify that the DFARS marking requirements could and maybe will limit restrictive markings on non-commercial technical data and software to those specified in those clauses, including it will place restrictions on any markings used directed at non-government third parties. So this is the one that might kind of clarify and make the Boeing case moot if it decides to specifically lay out in the final rule that it's going to also govern what kind of legends and markings can be placed on technical data delivered to the government, even if those markings are only related to the use, to third parties' use of the data. In our next case, we have, it's a little bit shorter of one, but as of this month, the DFAR, the regulatory control officers are still reviewing the proposed rule proposed in 2019 D044, but this case would implement a section of the NDAA from 2017, which provides that the DoD has until 6 years instead of 3 after DoD accepts the last item other than technical data under a contract, or until 6 years after the date of contract termination, to require a contractor to deliver technical data generated in performance of the contract. So this is something that we're definitely going to have to keep looking out for, but it would be a change from 3 years to 6 years, which will change contractors some of the obligations under the DFARS clause that must be aware of and maintain. And for the next case in the DFARS case 2023 D010, this would require an offeror to provide data to support a commercial product assertion for a subsystem, component, or spare part of a major weapon system. This rule is also still, we haven't seen a proposed DFAR rule come out, but the report was due on June 21st, yesterday. So we might be able to see more on this coming out soon. And in our next case in 2018, DFARS case 2018 D018, this was actually just finalized in a final rule on March 22nd. This rule amended the DFARS to implement a statute that requires the DoD, as part of any negotiation for non-commercial computer software, to consider all non-commercial computer software and related materials necessary to meet the needs of the agency throughout the life cycle of the software. So this new DFAR rule has DoD improving its acquisition planning and identifying and negotiating for software deliverables and license rights at a fair and reasonable price before contract award. These changes would include a change to the DFARS, to a couple different DFARS clauses, specifically one that deals with acquisition of other than commercial computer software and computer software documentation and associated rights. As related to procurement planning, this clause would require will, now that it's a final rule, requires that the procurement and requirement documents address the acquisition at appropriate times in the life cycle of all computer software, related recorded information, and associated license rights necessary to reproduce, build, or recompile the software from its source code and required software libraries. This rule also established that there are other source code alternatives for privately developed computer software. It also revised the definition and expanded the definition of restricted rights, and by permitting the government to make a reasonable number of copies of computer software required for other purposes authorized in other DFAR clauses. So this definition is revised to expressly indicate that the government has the right to use computer software and other rights to computer software already provided to government support contractors. We have two more rules. The second to last is going to be our FAR case 2020-010. This was a proposed rule that was actually just issued on April 7th, and it implements changes related to data rights that are necessary to comply with the Small Business Administration's SBIR so the Small Business Innovation Research and Small Business Technology Transfer Programs. Specifically, it updates terminologies, definitions, and data rights allocations to ensure consistency between the SBA policy directives, the FAR, and the DFARS, because each of these had different terminologies used related to data rights allocations. And so specifically, they changed the definitions to the computer database and computer software, and they revised them to comply with the FAR Part 2 to harmonize the terminology that applies both in these SBIR programs with the ones that are already used in the FAR and DFAR. So it's just going to be creating consistency between those programs. Additionally, this rule would extend the data rights protection period from 4 years to 20 years. So this would mean that the contractors also have to retain documents for 20 years. So it's extending a document retention as well. That is, and this is relevant to both the SBIR and the Small Business Technology Transfer Programs. Our last rule is related to the OTAs. This is going to be, so this was actually a final rule that was issued in May, and this rule permits the award of a follow-on production contract without the use of competitive procedures, even if explicit notice was not listed for proposal for the prototype project transaction. So that's specifically to OTAs and prototype transactions. And this concludes the rulemaking section. We'll go into the next ones and performance considerations with Rachel.
Okay, so more along the theme of the government trying to get and keep more rights so that they can use contractor data and IP as they see fit. There are updates to the DFARS in January of this year. And at this point, we are talking about data that has been marked or delivered or otherwise essentially performed under the contract. And so at that point, at this point, we're talking about what can the government do to say the contractor did not do this correctly. And the flight safety case that Megan previously briefed discussed this a little bit in the sense that under the old DFARS clause, the contracting officer essentially had to bring actual information or evidence that the data was not appropriately marked because it was not developed exclusively at private expense. And so the change to the DFARS is making that a little bit easier to bring a challenge in general. The flight safety case, their arguments were twofold, one of which was the government did not bring any information that demonstrated that the data was not developed exclusively at private expense, therefore it could bring no challenge at all. And then on the next slide, I'll discuss in a little bit more detail that even if it wasn't, it was appropriately marked. But in the context of the standard to bring a challenge on a marking, this case basically stands for the fact that there are multiple ways for the government to do that. In this case, the board said that the government was challenging the type of information marked, not its funding source. So it was not irrelevant where it was funded from, but it was just not what the crux of their decision was. Basically, the Air Force won the day by contesting the type of information versus the funding, and that was permissible by the board. And then in being able to challenge data markings, Megan already briefed this DFARS case. It is likely to increase the time period in which the government can bring that challenge. Next slide, please. So the substantive part of flight safety was if the data markings were appropriate or not. And I won't reiterate the facts that Megan already went over, but essentially, as she said, there is an unrestricted rights license in OMIT data, which allows the government to use it to manufacture and re-procure commercial items. There was some argument in flight safety as to whether or not the 21 drawings at issue were OMIT data or whether or not they were manufacturing or process data. As it notes on the slide, if it's manufacturing or process data, then the holding in flight safety would not have applied to those drawings. But in fact, the court or the board did find that it was OMIT data. They went through a lengthy discussion interpreting DFARS 252-227-7015 B1 and B2, and they went through the underlying statutory authority as well as the legislative history to try and determine what those clauses mean and what rights the government has with regards to OMIT data. And so that takeaway after they went through that analysis, because they did a comparison to the unlimited rights commercial clause, was that there essentially is very little practical difference between when the government has unrestricted rights in commercial data and unlimited rights in non-commercial data. This actually was one of our cases that we argued. It does not seem like we agreed, and so this case of note is under appeal. So everyone should stand by, and potentially there's some room for change there, but currently this is where the board stands on this issue.
Hey, Rachel, can I make a practical assessment for everybody? From a practical perspective, this case should send a shockwave through the commercial item supplier industry. I mean, the practical truth of this case, if it is upheld, is that if you have a commercial item and you sell it to the government, you have to have completely unique data to share with them that parses out what is commercial data that will receive one marking and other of the commercial data that should be parsed out as OMIT or other type of your general backlog of information that would be given to the government with more extensive rights. And instead of what has gone on, what the routine has been, which is commercial item contractors supply their data with their commercial markings on them, the government takes that and uses the item and uses the commercial data that's provided to it only to the extent that it's permitted under the terms. Now, commercial vendors will have to have a whole set of data separately developed and marked for the government customers, and another set of data that they mark and use with proprietary markings to their purely commercial customers. It's a problem, I think, that will hopefully get untangled over time, but it certainly is something to consider if you're in the commercial item sales market for the government. The other item that should send a bit of a shock to the industry is the assumption was that the presumption that your data is commercial, but for some significant amount of evidence brought by the contracting officer to demonstrate that it is not, was an end around was done in this case, and allowed the government to challenge the data directly without providing any evidence of that sort. So that safeguard seems not to have been effective, at least in this case. That's it, Rachel. Thank you.
All right, thanks, Steve. Okay, next slide. We'll just go ahead and pause here real quick for anybody licensed in the relevant states. The code word is presented on the screen. It's data. If there's anybody on the phone who can't see the screen. And if you could type that into the Q&A section of your Zoom window at this point, that would be great. And if not, we will remind you at the end. I think we can move on to disputes. Off to you, Steve.
Okay, next slide, please. I'm going to go through some cases. They're kind of a medley of cases. The one common thread that runs through all of these cases is they address government contract type issues in that setting. They relate to some sort of good or services being sold or acquired or used by the government. But beyond that, the thread that these are a variety of different types of disputes that we're seeing. I think Rachel summed it up as saying that we're seeing much more activity in the software, commercial software and non-commercial software disputes. We're seeing more activity in what is technical data. And the reason that's important is if information is technical data, the government typically will get some sort of rights in that data. And data that is not technical data, at least theoretically, the government receives no rights, and that information remains proprietary from commercial contractor information. So there is also a bit of activity in the patent area that we'll talk about in just a second. So the first case is a case we handled here, Raytheon versus the United States. It's an important case in our view, because it is the first time that we're aware of the issue of what is the scope of the definition of technical data and how should it be applied to industry and government. It is the first case that has really borne on that definition. The definition of technical data, I will try to summarize without reading. It's essentially any type of data of a scientific or technical nature, and it excludes financial and contract administration and management type data. That is the sole guidance that was provided to industry and contractors as to what technical data actually is. Nevertheless, as we've gone through this set of slides already, you can see that much of the rights between the parties pivot upon whether or not the information at issue or the IP at issue meets the definition of technical data. So this is an important case because it's the first of its kind addressing the scope of the term technical data. In this case, the government claimed government purpose rights and or unlimited rights, kind of a take your pick for type argument in the vendor list that was delivered by the company relating to a Patriot Engineering Services contract. That list provided names, addresses, cage code, and part numbers for all of the parts that have been purchased under various Patriot weapon systems types of contracts. The government asserted that this vendor list was technical data because it was, and that because it received these extensive GPR or unlimited rights. I mentioned what the definition of technical data is, but let me just kind of rephrase it again. It is data of a scientific or technical nature. It excludes contractor financial or contract information or management data. the government made a series of different arguments as to why this list of vendor names, addresses, cage codes, and part numbers must be technical data. And because it's technical data, the government received extensive rights in it. Those variety of arguments boiled down to one simple point, which was the list was helpful to the government's engineers. And because it was helpful to the government's engineers to do, among other things, acquire these same parts from suppliers that Raytheon had already vetted and spent a significant amount of its capital ensuring those suppliers were appropriate and adequate and qualified to provide the parts, the government could just take it and use it for its own purposes of acquisition. And because it was useful and a useful list to engineers to identify good suppliers for the government, the government claimed it must be technical data. Well, fortunately, the court disagreed, finding that the vendor list did not describe the parts or otherwise provide a physical or performance characteristics of the items in question. It was rather, the list was assembled from a variety of sources, but including sources of a financial nature like invoices and other types of payment and purchase orders for the parts that were used in order to develop the list as required by the contract's deliverable description requirements. And so the court found that technical data, at least in this case, does not include lists of important supply chain information that the contractor may maintain and spend its own capital in vetting its supply chain and suppliers when doing its work for the government. So that is a bit on that case. It's an important case because it starts to define the line between what is data that is provided under a contract that's financial, management, or administration, and that the company will retain at least theoretically complete proprietary rights in, versus data that, when submitted or required to be submitted through a contract, the government maintains some license in, either limited rights, GPR rights, or unlimited rights. And historically, it has caused a significant amount of disagreements between the parties that have not made its way to the court, and this is the first time that it has. And hopefully, this case will provide some guidance for parties to push back on overreaching government assertion. Okay, the next case is really a simple point to make. If you are a submitter of information and you're notified by the government that it intends to release, or it may have to release, that information under FOIA to a third party, intervene immediately. Get involved immediately, provide your response to the government, and help the government protect it based upon your assertion that it is confidential, commercial, or financial information. Because if you don't, and the agency goes on to lose in a FOIA case against a FOIA requester, intervening after the fact and trying to preclude or get a stay or stop the government from publicly releasing your data will not be effective. That's what this case more or less stands for. In this case, it was related, the FOIA requester had asked for all contractors' EEO-1 information from the Department of Labor. The Department of Labor advised contractors that it was planning to release it unless it was blocked from doing so. The FOIA requester sued the DOL. The DOL defended on a Trade Secret Act grounds, but it did not have information from this contractor concerning exemption for confidential, commercial, or financial information exemption, and it went on to lose that case based upon a variety of reasons that we assume, because it did not have information about the contractor's nature of data. The contractor went on to seek TRO and to stop the government from making the disclosure, and it was unsuccessful in this case to overturn the previous court's ruling that the data was publicly released. That's Okay, in the Gilead case, this one, these two cases are both patent cases, and they are pretty complex, so I'm going to try to just summarize them at the highest level possible to give everybody an idea of what was going on here. In the first case, it related to Gilead's HIV drugs that it was studying and with the CDC, working with the CDC to study as to combination of various drugs to fight HIV. Well, it entered into a series of agreements with CDC as to what the CDC was allowed to do with the data and how to deal with any inventions that might come up in working with the data studies coming out of the use of these HIV treatment drugs. CDC went on to use to do the studies, and based on those studies, a government inventor sought a patent for use of the various combination of drugs called Truvada for PrEP that would actually act and serve as a prophylactic for HIV patients from HIV infection. And it did not, and it failed to notify Gilead that it had filed for these patents based upon the data that it had been collecting and working with Gilead under these drug studies. Long story short, Gilead was precluded from using this invention for PrEP purposes without the government's consent due to this patent filing, and Gilead sued the government for breach of a variety of contract arrangements that it entered into with CDC as to how patents and other items would be processed in use of the drugs in these studies. This court found that the CDC had failed to notify properly Gilead of its invention and to use a variety of other types of contract obligations related to inventions in the context of these studies. And because of that, it entitled Gilead to damages of some significant amount, we assume, but the decision did not get that far. So that's how this case relates to government contracting, in the sense that when the government, enters into contracts providing for notice and other obligations and fails to do so, contractors, in this case Gilead, may find relief through other means, through contract breach type arguments made where the government takes advantage of the relationship under the contract and seeks IP rights for itself. Okay, in power density, this case is actually an authorization and consent case. It's a 28 USC 1498A, which provides for that the exclusive forum for hearing infringement cases by the government for infringement that is authorized and consented by the government shall be at the Court of Federal Claims. In this case, power density had a patent on cooling electronic components related to fluid that would pass through the PCBs presumably and evaporatively cool the electronics. DARPA, a DoD government agency, was conducting a variety of cooperative agreements and grants, as well as procurement contracts to further develop cooling technologies for electronic parts, and power density sued DARPA for the alleged infringement by DARPA's entering into cooperative agreements and grants with at least 8 research institutions and 11 defense contractors for work which power density argued infringed on its patent, and the work that was alleged by power density was done at the authorization and consent of the government. And so presumably power density believed that it had brought the case to the right place, to the Court of Federal Claims, because clearly DARPA was entering into these contracts with these third parties, and it must have provided authorization and consent, and that would require the power density to go to the Court of Federal Claims rather than to district court. against these various alleged infringers. However, the court disagreed. The court found that the 8 research institutions and others that were working on grants and cooperative agreements, those claims could not proceed under the authorization and consent requirements because those grants and cooperative agreements were not for the government. They were instead done for a public purpose. That's the purpose of grants and cooperative agreements, is to support the public welfare, not to support the government, or not to acquire items, services for the government. And those 8 research institutions were dismissed, and other contractors performing grants and cooperative agreements. The court went on to find that it was plausible, however, that the government had provided authorization and consent to various defense contractors that were working on a later stage of the DARPA program for actually developing and producing items that may have infringed the patent, and that were not done under grants or cooperative agreements, but instead under DARPA contracts, and allowed that part of the case to proceed. The bottom line of this case is it lays out a 2-part test for authorization and consent. First, the authorization and consent must be for the government, and it must be done with the authorization of consent of the government. Those are the tests to determine whether or not to bring your infringement case to the Court of Federal Claims versus bringing a case in the district court directly against the infringer. And it is a bit nuanced, as you can probably gather from the way the court reacted to the claims that were made here. And you should work with your counsel to determine where the appropriate form is in an alleged infringement matter. Okay, next slide. Rachel, I think you were planning on tackling the licensing cases.
Yeah, so this slide and the next slide kind of indicate where we're going on the software side. There are a lot of ways that contractors sell their software to the government. There are a lot of constructs, and these cases kind of hit on a bunch of different ones, which kind of indicates the nature of rising disputes in this area. So the Sciasoft case, the government bought 20 copies of single-use software. As you'll see in a later case, it might be a little bit of a red flag when the government buys so few licenses, because they seem to copy them without authorization relatively frequently. But in this case, that is exactly what happened.
We possibly, we don't know that.
Possibly, yeah.
These cases tend to give one pause, however, that occurs in a in a potentially significant amount of cases.
It's true. I'm sure the government is out there buying single digit licenses and using them appropriately in many cases, but in these cases they did not. So the government here bought 20 single use licenses, and in fact it got copied many times over, and actually that copying allowed non-government personnel to get a hold of the software, which was a violation of the license terms provided by the contractor. In this case, the government tried to argue that the license terms were not a part of the contract, therefore they were not bound by them. The contractor provided the license terms physically with the software after they had entered into the contract, and also via a click wrap license as well. But the board did not buy that, and they said the government is bound by those license terms. Essentially, they said what license terms would have been applicable if not these. They were the only license terms available, and the contract was for licenses. So essentially the board did not buy that, and the government is bound by license terms even if it does not read them. And then it also created an implied duty to take reasonable steps to protect software from being copied in a single-use setting. Looks like we're running a little bit short on time, so I am going to speed through these a little bit, but because we do have some substantive questions that I would love to take care of. So in the Avoo case, essentially this is a little bit different because Avoo sold software subscriptions through a reseller with an FSS contract. And essentially the FDA, the government agency at issue in this case, used the software to take a bunch of Avoo's data and then bring the operation in-house, essentially is what they tried to do. They didn't exercise the options that were available to them. They just kind of utilized the software to try and bring everything in-house. And that was, according to AVU, a violation of its master subscription agreement. However, the CBCA did not really hear it on the merits because they said we do not have jurisdiction. The MSA is not a procurement contract under the CDA, and we do not have jurisdiction to hear this case. They did say that presumably you could bring a breach of a license or master subscription agreement to under the Tucker Act at COFC, and in fact, AVU did that. They filed with COFC, but they also appealed this decision to the Court of Appeals for the Federal Circuit. So COFC is currently stayed pending the decision at the Federal Circuit. So procedurally interesting as well. Next slide.
The only point I'd like to make on that for those listening and are interested in commercial licensing with the government is it's a perilous area of law. It always has been, but right now as to finding the right forum and the right theories, assuming that the harm has occurred and it's clear, it's still nevertheless difficult to get a remedy from the government. There's a number of different impediments, including in this case jurisdiction, as to whether or not you can even bring a case as a software seller that you're selling through a reseller directly against the government. We believe that you can. But in this case, bringing it under the CDA is not the right way. Is not the right way, according to the CBCA. And CISASoft, just to contrast the two, CISASoft was a direct contract with the government. The CISASoft was the software supplier. It was the one that put the license agreement in the CDs that were delivered, and as well as had installation software that would require click-through agreement for the terms. Even though the license was not in the procurement contract, it was clear that CISASoft had a jurisdiction to bring the CDA claim, and it did successfully. That's
So bit management was an interesting case as well. The court found that the government breached an implied license by copying the software incorrectly or impermissibly. And this case also goes into essentially the difference between alleging a breach of contract for breaching license terms and copyright infringement for breaching license terms. And so this is relatively unique in the sense that you can in fact have an implied software license when there isn't an express one. That license can be breached. And that essentially the difference between bringing a copyright infringement claim and a breach of contract claim for a license is whether or not the term at issue is a covenant of the license or a condition precedent. The condition precedent of a software license essentially limits the scope. And so if a government customer exceeds the scope of the license, that is when they commit copyright infringement. There's a preference to view terms as covenants, so there's a little bit of an uphill battle in determining whether or not something is a condition precedent to trigger the copyright infringement claim. But essentially, this case sets forth a pretty good framework for determining when you may or may not have that and whether you bring infringement or breach.
Again, another example of the perilous journey towards relief. This is, you have to pick which one is it? Is it covenant? Is it precedent? Condition precedent. If it's condition precedent, then there is no license that applies. Therefore, a copyright violation should be pled and alleged. It's a perilous journey toward relief in this area, and careful steps need to be taken through it. And assuming, and that is all assuming that the harm has occurred. Getting to the relief is still perilous.
4DD came on the heels of bit management, and it alleged some of the same issues, whether or not there was implied license, and whether there was a breach of that or whether it was infringement. Though that did come out a little bit differently for 4DD, but in essentially what this case ultimately stands for is that the government purchased a perpetual license, and therefore that they felt that gave them ownership rights, and they made multiple copies based on feeling like the perpetual license gave them the ownership ability to do that. And the court essentially said, no, because you there was a license in writing that limited your ability to copy it. Because you agreed to it, you are not an owner of this license, and you have to abide by the terms of the software license. So they did breach that by making the excess copies of that software. But it did bring up, again, a lot of issues that came up in bit management. They were resolved a little bit differently or not resolved at all. And so it is continuously an area of the law in flux right now.
So this, just real quick comment, all the things Megan told everybody about as far as the rule changes, this is another example like the Boeing case, like the Raytheon case, like many of these where the regulations are being rewritten to address losses that the government is taking in these cases. In this case, the excess copy issue is being addressed in a regulatory change, arguing that restricted rights allows the government to, not arguing, asserting, allows the government to make excess copies in order to abide by other requirements of the government in other parts of the clauses. That was that issue in this case. You're seeing the evolution of the regulations through these cases, or at least the reaction to it. Go ahead, Rachel.
Okay, and lastly, Lockheed, which just came out at the end of last year, it has to do with software development and what it means to essentially be developed. Because if it is developed exclusively at private expense, then obviously there is no basis for the government to obtain a set of rights to it. But in this case, the government and Lockheed were fighting over whether or not the software was in fact developed. Lockheed argued that in fact it was, and all at private expense, and the government said that it was not because it had not been reduced to practice or implemented essentially in the way that it was meant to be. And the court or the board found that it does not have to be, that is not within the definition of developed. And this corroboration requirement, which as the Navy meant it, was requiring the production of contemporaneous evidence of development, was not necessary. The Navy was essentially arguing for a heightened standard here, and the board was not going to buy that. So there is no requirement that requires that kind of showing with regards to evidence of development contemporaneous with its development, and there is no actual reduction to practice required in order to call software developed for purposes of government data rights.
Okay, really quick on this. In patent law, in patent regulations, the government receives rights in the patent if from a very long period of development, all the way from conception, all the way to actual reduction of practice. Actual reduction in practice typically requires testing to show that the invention works as intended in the environment intended. That is for the government's benefit because it receives a license anytime along this period of time of development, the government funds it. Okay, the Army here was trying to take that and transfer it into the area of technical data and computer software, arguing that the term developed meant this very, very long period of time, all the way to testing in a practical environment, like in patents. There's no basis for that in law or regulation. So it's not surprising they lost, but I guess you can't fault them for trying. In this case, it would have been important to Lockheed because if they had to test the software in the environment intended, the F-35, that would have been pretty hard to do without government funding, but they did not. Development was complete and it was entirely an exclusive at private expense prior to government funding being involved, and in this case, that meaning of developed is what applies to technical data and software for items, components, and processes. It's a much more narrow definition than that. So it's an important case in that sense. That, like the technical data, now we have a definition scope for developed, both areas of continued disagreement between the government and contractors over the years. And that's it. I want to thank everybody very much for joining us today. I don't think we're going to have time to go through much Q&A today, but we will get back to everybody who asked a question. So before you log off, if you want to ask a question, ask it, and we will get back to you with a response.
Yes, thank you, Steve. We do have some questions that didn't get answered, and we'll make sure to respond in email. And so put your questions in the Q&A and we'll get back to you. We also want to just remind everyone in approximately 15 business days, you will receive an email with a link to your CLE certificate. And as a reminder for those in the New York, New Jersey, Pennsylvania area, the code word requirement of data, you need to put data into the Q&A to make sure you get that CLE credit for New York, New Jersey, and Pennsylvania. Thank you for joining, and I hope everyone has a wonderful day.